All 12. Thank you. You all may be seated. Madam Foreperson, I understand the jury has reached a verdict. Is that correct? Would you please hand it to Mr. Terrell? The court will look it over first. Then I'm going to hand it back to you, Madam Foreperson, to read it out loud, called publishing in open court.
Yeah. Let's start with this, and then let's talk. We've been with this trial for...
All right, Madam Foreperson, if you would read the verdict from top to bottom, you may remain seated. If it's easier for you to stand, you certainly can. If you'll pull that microphone in front of you down to you, read it from top to bottom. It is called, again, publishing the verdict. Thank you. You may proceed.
Okay. The jury finds the defendant on the following counts. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, felony murder, guilty. Count 4, felony murder, guilty. Count 5, felony murder, guilty. Count 6, burglary, guilty. Count 7, aggravated sodomy, guilty. Count 8, rape, guilty. Count 9, aggravated assault, guilty. Count 10, aggravated sodomy, guilty. Count 11, arson in the first degree, guilty. Count 12, possession of a knife during commission of a felony, guilty.
All right, Madam Foreperson, if you would present that verdict to our...
I boomed. At first, I thought, no, I'm going to take a day off. And then after half taking, well, you do know, I do have a full-time job and everything, but it's 8 p.m. where I am. And around 6 p.m., I thought to myself, I can't be the only one replaying this over and over and over. And you guys have been in mine, in other people's, in other channels, chat and watching with us, all the content creators, trying to get sense into this. Now, I'm used to it, to mope alone. But around 6 p.m., I felt that, no, I need to talk to people about this. And the best people to talk to is you. So spill your hearts out in chat, and I will try to get through a few things. Let's see if I can make this bigger. Yeah, I could. I wish I could have half the screen so it could roll by. Now, folks, this is one of few occasions where this is a one-sided stream. Now, if you are on, of course, the evidence was all there. Be respectful. Be respectful, because this is us trying to not cope, but handle and go through why. Katt, I can send you a link. Now, I do know that you have something planned with Jim, because I tried to recruit him to this stream, because I have a few things I'm going to go over regarding local law and precedents. Mark, I'm more bothered by this conviction than Richard Allen's, to be honest. I can understand why. I really can. Mainly because we got to see this injustice. And it makes it more real. And this is one of the reasons, I believe, in the common knowledge kind of thing, this case became bigger. In the immediate reactions and stuff, while in the Rick Allen's case, that trial, the Delphi trial, we were a lot of people who were invested for years, while this was dropped onto us. And I believe that the similarities between this and the Rick Allen case is, well, in Rick Allen's case, there is literally, figuratively, zero evidence. In this case, you had the DNA. In Rick Allen's case, it was the confession he made after 5 months in solitary confinement and while drugged up. This case denied Mr. Faust a proper defense by being a cold case. All the records that could have shown he was somewhere else, long gone. Phone records, everything. Witnesses who might have seen him somewhere else, long gone. His stepmother passed away 6 months before Faust was arrested, so she couldn't provide an alibi for him, allowing the state to imply that he was at his stepmother's. And so, in retrospect, using the fact that Edrick's stepmother died against him, it speaks to the fact what they were prepared to do. Now, we saw it with the lead investigator. And how the prosecution claimed they were after the truth, while it was obvious, at least to me and to many of you guys, they were going for conviction, excusing everything regarding the, in my opinion, more probable and almost, I said it during Chris Melton's testimony, yeah, I believe that's the guy. I believe that's the guy. But we are here for the why. And I've been reading, now, there are a lot of the usual trolls who just says, 100% guilty, you all are, and then some remarks, I ignore them. But there are a bunch of people who has legitimate whys. And the number one thing when it comes to the evidence is the DNA in itself. And Bob Mara have said this for a while, and I agree that the defense, if they would, they should. One of two things, but I go to the second thing later. They should have challenged the DNA much, much harder. Much, much harder. Now, the third-party culprit defense is a great defense if you have a jury that is at least at some point, to some extent, critical to DNA in itself. Now, I say it, and many others say it with me, DNA is absolutely worthless as evidence without corroborating evidence. In this case, DNA here means shit for nothing if they can't explain why the doors were locked. Shit for nothing. DNA from Faust means shit for nothing if the DNA in the actual graped area belongs to somebody else. Because then you have a reasonable explanation to go towards reasonable doubt. Malcolm says here, I don't understand why you need to attack the DNA. The DNA is so what to me. And I agree with you. But there are a lot of people, and probably 12 euros, who says, no, DNA. His DNA shouldn't have been there. It shouldn't have been there. Oh no, it shouldn't have been there. And that comes into, oh, but they didn't give an explanation why it was there. They weren't allowed to speculate on Faust and Tara may or may not have met at the bar, where the defense had a witness to say she thought she saw Tara there the night before. A bar which allegedly Mr. Faust was known to frequent. The judge didn't allow it because of the Georgia grape shield law. You are not in any way, shape, or form allowed to bring in the victim's sexual history. Yeah, why didn't they send the other objects to retest for more sensitive testing? Because it's the prosecution and they had their guy. Why risk ruining that? Once you have the results you want, as a prosecutor, why bother? And for the defense, well, they could have. First of all, they have to ask the court's permission, and then they have to have the funds for it. And somewhere in the back of my mind, Mr. Faust doesn't have any money. So, limited resources. Limited resources. I'll send Katt a link. I know that Katt and Jimmy are getting together soon, but I'll send you a link anyway, just in case. Check your DMs, Katt. So, and when it comes to the DNA challenge much harder because of the true allele is a technique, it's a program, it's a software that is patented and patented/copyrighted. I mean, all the things, they protect all the things with the true allele testing. And that's a problem because that you can't challenge the technique behind it because the technique is a trade secret, which in this case should have made it impermissible as evidence. Because if you as a defense aren't allowed to challenge the technique behind or the steps, the technique. How do you get there? And they say that's a trade secret. Then it should never be allowed. Never be allowed as evidence in trial. But it was here. But it was here. And then, because you who were here during my videos and my streams, I've been arguing from now to kingdom come about, but the state opened every door to her sexual history. And thanks to Mr. Fleischman over at X, who sent me this. Let's see, can you see it properly? There it is. Let me read it. This is from Georgia Appeals. It is a different case, of course. The testimony attorney sought to elicit by cross-examination that the victim had schmecked with other men is the very type of evidence prohibited by the Grape Shield Statute. See Brown v. State. Its two exceptions are exclusive, Lamar v. State, and it is well settled that the Grape Shield Statute supersedes all evidentiary exceptions, Logan v. State. The defendant's right to confront and cross-examine witnesses concerning the victim's past behavior with others must bow to accommodate the state's interest in the Grape Shield Statute, Harry v. State. Therefore, we find no merit in Turner's argument that the state opened the door to evidence which Turner admits was protected by the Grape Shield Statute. The trial court did not err in refuse to allow this testimony. Which means there is no opening the door exception to the Grape Shield law. I was wrong. I apologize. In my mind, the right to confront should supersede. But as of now, in Georgia, it does not. And these cases that are cited here. Oh, hey, Katt.
Hi, it's good to see you. I'm glad you're doing this.
Yeah, I came to my senses a couple of hours ago and said, "Now, I mean, there are a lot of people who still need to talk about this." So I thought, yeah, and so do I. Because
yeah, I saw you're just talking about this case law. I mean, I would love to see SCOTUS address this issue.
And this, in even reading, and I understand that the court says, this is it. Yeah, but this is one-on-one. There is no third-party culprit. This defense here that they are talking about here is, well, I apologize in advance. Well, look at how slutty she is. Of course,
yeah, it's not a credibility of the complaining witness.
Yeah, which, in my opinion, it's not the same thing.
Well, and if there's no way, like, to me, it seems like there's a way you can open the door, but we're going to say all of the ways to open the door they don't have merit. So essentially, there really is no practical way that the state could open the door. So
exactly,
it's like a blanket denial of a response.
Yeah, and but as I do remember, what they try to argue is that we are not going into her sexual history. We are just arguing the possibility they might have met somewhere.
Well,
but that's
not
still
even that. It's there needs to be some type of adjustment if we're going to have a rise in cold cases that are brought to trial because of advances in things like DNA technology and evidence. Then we need to adjust the way that we balance laying foundation for things. Well, if you need to establish by preponderance of the evidence with a good faith basis at contemporaneous trial, like something happens in 2024, it's going to trial this year, and you wanted to say, well, somebody said they saw drunk people at a restaurant, a Mexican restaurant, that Thursday night. Well, did you go get the cameras? If you didn't do those things right now, it's not a good faith basis to want to just tell the jury that. But if we're speaking 25 years ago, what more could somebody practically do to go and verify that now? And it's on the state to not have gathered and followed up on that lead in the first place.
Yeah. But
so there needs to be some type of balance that makes sense in the context of a cold case.
Yeah, and as of now, there are no case law like this one. There are none. So, which makes this case a possible case law, because here it's not one-on-one, because in those cases, it's not disputed that there was sex involved. From one part, it was, you're going to have sex with me. The other part said no. And then they argue because there is a bit word against word, of course, with other evidence. This is not that type of case. Here they have a third party culprit with the same or a larger amount of DNA on her. And they are not allowed to argue against the state's narrative that, no, Chris was consensual. This was rape. And for me, it's completely different from the case law. But the case law as it stands now allows the court to just say no. The state cannot, by statute, open the door.
And then the higher courts can address it. They could be aware of this case and they could have thoughts on it, but they can't just out of nowhere address it. And what I think is interesting is if the defense had called a DNA expert, and even if they weren't able to talk about this specific Mexican restaurant where somebody said that they saw the girls in this sorority that night and maybe one of them was Tara, the idea that you could ask a DNA expert, all right, so let's say you go out for drinks and you put your hand, it's Bob Mata's example with the peanuts, that they always put the bowl of snacks out at the pubs. You know, could DNA transfer that way? Those specific examples could illustrate, give you the picture of what two individuals that were the same age group, which I'm wondering if that was also lost on the jury, because they're seeing Edrick Faust as he is today, and they're only seeing pictures of Tara Baker, the age she was when she died. They might think, you know, the age disparity, why would they even be in the same place? But getting it across through a DNA expert that this encounter didn't even need to be involving sexual intercourse at all. And there could be trace evidence of DNA.
Yeah.
So.
And let me bring up another case I was made aware of. This is the Lucas Anderson case.
It's spelled weird, right? With the I?
Let's see here. L-U-K-I-S. Anderson, one S. It's the Marshall Project. This is from 2018. In 2012, there was a robbery where the store owner was taped up, beaten, taped up, everything, and then the masked assailant left. Assailants, plural, left. In this debacle, Lucas Anderson's DNA was found on the nail clippings of the store owner. So of course they brought him in. He was charged. They were going for the death.
Gonna think
they are going for the death penalty.
Dang.
And then months later, they are more or less preparing for trial. Lucas Anderson was at a hospital for alcohol poisoning that entire time as the crime was committed.
You would think they would be able to find something like that out.
Yeah, but here it was. They picked him up soon after the crime. Because he was in Cody's, of course, because raving alcoholic with violent tendencies, of course, he is in Cody's. But this time his alcoholism saved him because he was at a hospital for severe alcohol poisoning in another town. He literally couldn't have been there. And this, folks, is transfer DNA. When DNA transfers via other objects between that person and the victim. And they got this absolute... so he was released. But
I'm not trying to be weird, but I feel like there's several ways that if we take at face value that the swabs, which were A and B, if we take at face value that the swabs that were labeled as oral swabs.
Yeah.
Because the other naming schematic for the anal swab was a different numerical, like it was not in sequence. So it kind of makes sense that the oral swabs could have both actually been oral swabs. I can think of ways that DNA can get into somebody's mouth and then also get into the vagina if we take it at face value. Like, what if you have something in your purse and then you use a tampon or something? And I'm not trying to get TMI, but the idea that there are people out there that can't comprehend. They can't comprehend.
The state's own theory is Faust, this elephant trunk sucking up DNA and transfer it somewhere else.
With a reset. It's like, it has to be both. You have to reinsert and you have to reset the clock. Jim! Oh, the Nevada shirt, my favorite.
Oh, I almost thought, are those prison cell bars? No, it's a window.
I don't think you can hear us talking about him.
I can hear. I can hear. I see I'm half Swede, half American.
I was laughing at the map thing that you posted yesterday where it was like the greatest insults in each of the states, and Maine was just Maine.
That was upsetting.
Yeah. No.
Oh man. So yeah.
Now I went through just a second ago, but I want to hear your opinion because you are an actual practicing criminal defense attorney in Georgia.
I mean, I'm not licensed in Georgia. I just practice there pro hoc.
Okay,
now and again.
Yeah.
So I don't want to get myself in trouble.
Yeah.
Yeah. I mean, I didn't follow everything. Oh, on the rape shield stuff specifically, or just general?
Yeah.
Well, Georgia's statute is like
it's complete
barring of any.
Yeah.
Yeah. The state literally cannot, according to current statute, the state cannot open the door for the defense to bring in history.
Yeah. I mean, I think that's kind of crazy. It just kind of diverges from legal theory in every other area. I mean, maybe there is some other niche area that I don't know about where you can't open the door. But I mean,
I
don't really have much to add to that.
But the statutes here are the one-on-one encounter where they can't bring in her history.
Yeah, and
but this case is not a one-on-one encounter. This is two conflicting, a third-party culprit.
Yeah, and I mean, I just read the text of the statute, and as I recall, I mean, I didn't watch every second of the trial, but as I recall, they were mostly where the issue came up was it wasn't even really about her past, sexual history as much as had these two people ever even been in the same place at the same time with respect to the Mexican restaurant. And to me, that doesn't even reach 412 as far as I see it, as far as I read it. Maybe I haven't done a deep dive into the Georgia case law. I've never had one of these cases, but
your favorite homework assignment.
Yeah. But according to the judge, no, if you are even remotely going to address, since the prosecution says this is consensual, this is rape, if you even want to try to dissect that and counter that, you have to make a 412 motion. Which, I say, Bob Mata has said this for a while. If the judge says file a 412, then file a 412.
Yeah, that's fair. One thing that I think is interesting is this is as far as post conviction goes, which is kind of how I'm looking at it. It's almost good at this point, not back then, but now that the judge said on the record you didn't file a Rule 412. Because now the next attorney, which I hope there'll be another attorney because it's always good to have a second one, argue the motion for new trial, can say, this guy, Cruz, he messed up. He didn't even file this motion that was critical to the defense. He, it was just strategy, clearly a part of his strategy, but he didn't, do it competently. So it's ineffective assistance.
Yeah.
So now that we're at this point,
Yeah, but I don't think this will affect his reputation as an attorney, because he did, after all that went on pre-trial and trial.
Yeah, for sure.
He did what he could with what he had.
Yeah. And I mean, it's like if you're a good defense attorney, you want to be found ineffective because that means your client gets another chance. Andrew Fleischman has a joke that he tells where anytime he loses a trial and there's an ineffective assistance claim, he gets excited because it means the prosecutors are going to compliment him for an hour about how great of a job he did.
What I'm wondering is if they tried Melton, let's imagine Melton was on the stand, the prosecution would want to be arguing, and you were mad that she was talking to other men, so you strangled her. And like, wouldn't that be the same accusation of sexual behavior of the victim?
Yeah. Yeah.
Like, I just don't get when the line is crossed and when it's not.
Yeah.
And I don't know if you saw this, but we talked about the Lucas Anderson case. Where did it go? Nick, stop. No, there it is.
Oh, so I was going to say, I meant to research this, but I was looking at the statute. This is kind of a law nerd issue.
Yeah. Oh, go right ahead. Nerd away.
I don't know the answer to this at all. But 412 in Georgia, it applies to specific offenses. One of them is rape, yes.
Yeah.
But murder and like arson are not among the offenses to which 412 applies.
Yeah.
I'm just wondering if you'd have to like bifurcate a trial if you have some that's 412 and some isn't.
Yeah,
or
because the statutes are all just rape.
Yeah.
Case law. This was a much larger trial, and these other cases, there were no third-party culprit involved.
Yeah.
None whatsoever. So, but it's still under the judge's discretion, of course, and we kind of know this judge, how many motions was still unanswered at the end of trial? 12 defense motions were still unanswered at the end of trial?
I mean, to me, I think one being unanswered is too much.
Yeah.
So once we're above one, there's kind of an issue to me.
And she punted it forward, and I believe most of those if this happens in our case, the defense case in chief, then this motion applies, and we punt it forward to them.
Well, and it's like, to me, I can't get over, like, there was pre-trial stuff about Brenda Swinney where they wouldn't enforce a subpoena for Brenda Swinney. So.
Oh, he did file a 412.
Yeah.
That's
what I understood.
Okay.
But I mean, at this point, the judge said that he didn't. So I don't know.
Okay.
I think
you could argue both sides of it. You could argue both sides of it. You can argue if he didn't file it, you argue ineffective assistance. Then you say, in the alternative, if he did file, then the judge erred or abused their discretion by not ruling or not admitting.
Yeah.
All with the impact of denying a constitutional right to fair trial.
Oh, Jim.
Oh, that's a Georgia statute.
Yeah, can you explain how the arson and burglary were even allowed so long after the statute of limitation expired? Yeah, this is a Georgia statute. See, now
Which
this
I want that to have an issue too. That to me seems kind of
because the only type, because we heard this in the YSL trial. Well, since this is a RICO, that crime with the longest expiration date, so to speak, it is that applies to everything. So if they had gotten rid of the murder charge in the YSL trials, then by statute, many of it wouldn't have happened. But theoretically, all the others would have gone. I know. I saw you.
I just had a visceral reaction when you said that.
But theoretically.
Yeah. I mean, I think this case is an excellent example of why we have statutes of limitation. It's not because we want people to get away with stuff after a certain amount of time. It's because
the evidence is gone.
Yeah, exactly. I think
I woke up today questioning the statute of limitations on murder, and I've always taken that as a given. I've never questioned it before. Like, we should always be able to prosecute a murder. And today I woke up like, can we always prosecute a because usually the situations I'm used to seeing are down the appeals train, like years have gone by, convictions overturned, and then everybody's like, all right, all these witnesses are unavailable, we're not going to retry this, we're making the decision not to retry. Or the judge is like, look, I'm not going to let you retry this because you just don't have evidence anymore that you had 20 years ago. It's never been like the first trial. I've never watched a trial of first instance where DNA gets us into a new trial and there's no way for someone to defend themselves.
Yeah, I think it's kind of counterintuitive in a way where it makes sense. It feels like murder, because it's such an important crime, we shouldn't have a statute of limitations for it. But at the same time, it's also the kind of case where people are going to be emotional and maybe a little bit less rational, and they're going to want to get a conviction on it. So maybe it's even more prone to error. Whereas if it was like a simple assault that you try 25 years later, people are going to be like,
go do your week in jail.
What is this? This
is stupid.
Yeah, and it shouldn't make a difference. And I do think this kind of started to come up in Wolfenbarger. I was afraid of it in Wolfenbarger, and I saw some of it here, where I think that the state actually has kind of benefits from a lower burden because they can say, "Oh, it was 25 years ago. This witness doesn't remember."
Yeah,
this witness,
the judge here, she addressed it when it came to the handling of evidence. With when they first of all the empty evidence bags, which was
stupid,
and the prosecution just no, don't open them. Not necessary. Why do you seal empty envelopes? Well,
do you know what I think the bigger issue is? I think there's a huge chain of custody issue. Don't get me wrong, and like even for things that might be accidental, let alone something intentional. But the idea that you need to introduce all of these exhibits that might not even have anything in it, to me, just shows you're trying to get ahead of someone saying you didn't do a good investigation. And you're showing all of these objects just to paint the image.
Yeah.
Which is, it's like a subconscious admission that you don't have the evidence.
And once they open up this actual, where their hairs and stuff was, some of these glass slides were cracked. And the judge said, well, it's been 24 years, stuff happens.
Oh, and in closing, Kalki said that they weren't broken when they were analyzed, and I don't think we have testimony of that.
No.
We have one person saying they would have been remounted before being analyzed, but then the person who actually does the analysis said she didn't know.
Yeah.
That she was the one that repaired them, but it was after they were sent to her, after they'd been analyzed.
Yeah. and still, it doesn't matter, because this stuff was supposed to be in a stored, secure something somewhere, where they lost the window screen. How do you lose an entire window screen from an evidence locker? Yeah. Now,
took it out the window. I don't know.
Yeah. I mean, hey, I'm remodeling. I need one of those. And then when this was brought up, the judge actually went on and said, this is a cold case. All of this is circumstantial and implying I'm going to lower every standard of evidence.
Yeah. I will say the Georgia Supreme Court's been kind of on a. They've been on, I don't know, what's the Southern saying for this? They have a bug under their saddle or something about about delays just across the board in the judicial process, both pre and post conviction.
Yeah, I read that 13 years between filing and they actually had a hearing.
There's a longer one. Somebody commented under that post about there was like a 22-year wait on a motion for new trial hearing. It was just ruled on by McBurney like a couple days ago.
Wow.
It was 22 years for a motion for new. So he's on his first appeal.
After 22 years.
Yeah.
Welcome to Georgia. And you have people
spur in their boot. There we go.
But bug under the saddle. This is by Jim. No, fuck. You have this on your
Robichaux.
Thank you. That one.
Because I used to pronounce the whole thing.
Yeah. Yeah, I know. But then again, I pronounce. I blame my accent. That is why, for instance, in the Laura Owens case, I keep calling her attorney for ginger ass, and I blame my accent.
Let's see. Demeaning of Cruz in front of the jury and witnesses really swayed it. Yeah, definitely possible.
Yeah, but when it comes to why in this, and I've seen and I started out with this as well, is one of I always say DNA evidence is worthless without corroborating evidence. It means absolutely jack shit, nothing. And I think the biggest issue in the entire trial is how the re-technique that was used against Mr. Faust in the interview. They got him to incriminate himself, and then they hit him with, well, we found your DNA. And then he said, well, take me to jail. This is why you shut the fuck up.
Oh, always. Yeah, absolutely. In every context.
Yeah.
I shouldn't say every context. Not if you're like with your friends at a party. You don't have to shut the fuck up.
Yeah. But if you are actually called into an interview with cops,
and they do this thing.
Am I detained? No. Okay, I'm out. No. Stay. Okay, so I am detained. I want a lawyer.
You know what move I hate? I just read a transcript about these yesterday, and it reminded me of how much I hate when they do this. Oh my god, they call in a witness who knows there's been a murder, right, or a crime, but in this case, it was a murder, and they ask him like, "Where were you at this time?" And this person was like, he knows what time the murder happened, and they're asking him about the same time as the murder. And they're like, do you know this person? And this person knows that this other person, they're asking about people that were involved in the murder. And then eventually the person cracks and says, look, I had nothing to do with the murder. And they say, did you hear us say you had anything to do with the murder? Like it's some kind of we all know where you're getting at with this. And then they try to treat that like it's some incriminating thing. It drives me insane. Yeah. So no, don't ever speak because
and it boils down to cops are allowed to lie in the United States. I mean, it's United States and communist countries, which is mind-boggling to me. Why you allow cops to lie? And I read that old statute from back in the day, and it is so originally. It is so limited, but over time, the goalposts. Yeah.
Like Aaron's, you can always talk yourself into an arrest. You never talk yourself out of one. Another thing is, if you're innocent, you don't know what's incriminating and what's not. So if you're innocent, you have even less. You should definitely not talk because you can admit to something is innocent, but they can use to incriminate you. Like.
Well, and then those words are going to be played in front of a group of 12 people that think they're only here because you must be guilty already. Yeah. So you get people that are like, why would he deny knowing her and not be able to think outside their own box, which might be empty, and go, hey, they haven't even shown a picture of the girl that they're asking about yet. They haven't given a name yet. They're still just talking about girl who died in a fire. Oh, I read an article about that, which may or may not have a photo. And even if it did have a photo, might you put two and two together? And there are people out there that really cannot relate to why he would have answered that way genuinely. that he only would have answered that he didn't know the girl because he was lying and it was some admission of guilt.
Yeah, I wish he just had shut up. I mean, we know Mr. Faust has a record. Now, but you assholes who say, "Oh, he's a career criminal," he wasn't in 2001. You fucktards. He had made one, maybe two, before 2001. That's not career criminal. You have to apply by the actual standards. 2001 and before that. Not, oh, what happened after 2001? What the state can argue consciousness of guilt or something, or consciousness of that. But that, in this case, that applies to Chris Melton. How he acted after the crime. With immediately trying to date other women. Because he was so distraught.
There's a Fulton case, or I think maybe about a year ago, where there was a guy, he had gotten like 20 years for maybe having crack, like one crack rock. He had no history of violence, and he was like 40 when he went in. Then he gets out, and he was violent. And people are like, "How do you let this violent criminal out of prison?" Like, well, he's been in Fulton prison Georgia prison for 20 years. Like, of course he's going to be violent against
yeah.
Have you read the conditions about Rice Street? Like,
yeah, I mean, half the prison is closed down because it's killing people. And here's one of these things when people are, oh, we have to be. It's not supposed to be a vacation, folks. Everybody but the people in for life will at some point in time be outside of the walls. What type of person do you want to have outside of the walls? At least there are people out there, no rehabilitation whatsoever, no halfway houses, nothing. It should be. And I'm like, oh,
yeah,
you sweet summer child. Have you ever been when you were a kid and you were in a timeout by your parents? Were you angry when you were let out of the timeout? Yeah. How about that? Now 20 years.
Yeah. Somebody asked a question. It's interesting. Oh, success 2020. So when they request to use Faust priors to establish him as a recidivist, does that mean as of 2001 or since 2001 to current? That would be different. That would be for sentencing. So you could use that for sentencing.
Yeah.
You could use everything for that's definitely different.
Yeah. But in this case, with both guilty of malice and felony murder, it's going to be life without parole. I mean, there's no question about it. It's just how many years can we add on after that? Did you? Oh, by the way, did you see the governor made a statement about this case? And he's roasted.
He walked right into it
in the comments. Absolutely roasted.
I loved that. And then there's like randomly there's one account that I remember that used to have like really dumb takes about Karen Reed stuff was in there like, yes, great job, Governor Liz and Jeremy. Like thanked the GBI agents by their first name. I was like, of course, this account is in there.
Yeah, and then we had allegedly Chris Albert, who is, of course, 100% guilty. And there's you? Now, we don't know if it's actually Chris Albert behind the account, Cowboy is something, but it's...
I think that's the account I was talking about. Yeah. The dog picture. I guess that doesn't narrow it down. Everybody has a dog picture. I usually like seeing a dog picture pop up, but not that one.
Yeah. But trying to go back. Why? And I mean, the DNA, together with how Faust said, I don't know her. Distancing himself. Now, folks, he might not remember it because it was a chance encounter at a Mexican bar in the middle of the fucking night. He might not remember. And convenient, and this is because I've seen the theory in my comments. Edrick Faust's stepmother died 6 months before. And they used the fact that she was gone. She could no longer provide an alibi.
Yep.
They only had to imply he was near that night because she lived there and he used to visit. And using somebody's death to counter a possible alibi. And this is the problem with cold cases.
Yep.
People die, evidence disappear, phone records are gone or not admissible. Like in this trial, phone records, no, can't, because the phone company used back then is now defunct.
Yeah.
Has been for 15 years.
Yeah, that's like the John Lewin case, the prosecutor from the ASAP Rocky case, not that case, but a previous case he did that got overturned by the Ninth Circuit. There was an alternate suspect who was the last person to see the victim alive. It had, I'm not going to go into the full factual background, but he had, it's reasonable to believe that he could have done the murder, certainly had the opportunity, but he had died in the interim. And Lewin basically did a motion saying we can't mention this person because he's dead, he's not here, we can't cross-examine, yada, yada. But then in closing, so they didn't mention him, but then in closing, Lewin said, and there was nobody else that could have done it. And he got the conviction. That eventually got overturned. But that was just a couple years ago. So, I mean, this gets back to the statute of limitation things, man. Things disappear. Guns get destroyed by unethical prosecutors. Named Adrian Love.
No. Here's the difference between a troll that I kick out and somebody who makes an argument. Surprised people want to convict Chris Melton. The lead detective made it clear Chris Melton was not on trial. Well, first of all, that's not what that's not how this works. The lead detective does not determine who's being tried or not. They present the evidence to the prosecutor, who then determines. But in this case, the lead detective coached Chris Melton on how to explain away. Did you see that part, Jim?
I don't think I did.
Her testimony?
GBI agent Liz.
Let's see if I can bring it up.
She had to say 7 times that he needed to have seen Tara sooner than 10 days. That was what he initially said. Because otherwise they couldn't separate his DNA from the bad guys. Because it wouldn't have survived for the 10-day period.
I made this short, just this quick.
But then you told Chris, you didn't kill her, but you were the last person there before she got killed. Do you remember making that statement?
No, I do remember making that statement, but that was in the context of me giving him that narrative of the last, or giving him an out with that narrative.
Any comments, Jim? You're muted.
Probably for his own benefit.
I have a ton to say about it. I mean, it's kind of speaks for itself, Evidence speaks for itself. It's just bad questioning.
Well, and that goes to the point of the comment is, was clearing, it's a third-party culprit defense, so was clearing the third-party culprit, that's a fact in dispute, and obviously the jury, I think the jury was choosing, do we think it was Melton, do we think it was more likely Faust, and not considering the reasonable doubt standard. I think they were picking one or the other, which sometimes psychologically, I think that's what happens with the other, some other dude did it defense.
And if Chris Melton had been on trial, his swaying back and forth between 10 days and 6 days would have been used against him if he was the one on trial.
Yeah.
But here
they would have told him 6 days was too far away. Yeah.
And it is. It is too far away according to the state's own theory on how Mr. Faust, who apparently doesn't have a peen, he has an elephant's trunk, who sucks up DNA evidence and disposes it at another place without leaving his own DNA there. But according to the state's theory, now with what if they were at the same bar and ate from the same peanut bowl? Yeah, with the transfer DNA theory. Well, yeah, it's the same thing. Let's now say Melton did the bad things to Tara. If he forcibly put his thing in her mouth and then downstairs, would that transfer Faust DNA from the mouth to the vagina? Under the same exact argument the state made under to explain why Chris Melton's DNA was in the graped area.
Yeah.
And still, 6 days is too long. Even with the transfer.
Yeah.
Alleged transfer via the elephant trunk method. It's
Yeah, I missed probably because it wasn't there, but this whole reset thing.
Yeah. And I'm
It's GBI. These are GBI employees testifying. And
they graduate from Chuck E. Cheese?
Well, but that's the thing. I think it's lost on people that these are witnesses called by the state who work for the state, who are sent. It's crime lab employees and forensic, because they have two different departments that they called for the purpose of this trial: for forensic science and then the crime lab that they had come and testify. But they're both arms of the state, and all of their inputs come from the DA's office or law enforcement somewhere in the state of Georgia. So, like, this idea that DNA doesn't lie, well, you're doing the collection, you're handling the collection with all these different steps, and then you're calling someone from the state to testify to what they already think the state is looking for by sending the stuff to them in the first place. And so then we get this testimony from Ashley Hinkle from the GBI that if drainage can't explain it because there's no semen would give you the like liquid vehicle for something to drain downwards if someone's laying on their back, I guess, into the anus, which still doesn't make sense because gravity doesn't just exactly do that. But if not drainage, they have this woman, they ask this witness, well, then what else could do it? And she says reinsertion, and could it reset the timer? Yes. I've never in my life heard that something that's degrading.
Yeah, what timer?
Yeah.
Is there a timer?
If DNA that's in semen, which has protective coating that other types of cells don't have, so we don't have that protective coating. There's studies that have shown like the max time that it could be detected would be like 24 hours in the oral cavity, 5 days max or something like that on vagina, and then 3 days in anal. And they needed to explain the 6 to 10. At first, Chris Melton said it'd been 10 days since he last saw her. Then in 2024, when GBI Liz is talking to him, he goes, well, maybe I saw her that Sunday. And then they try to say that wasn't the first time he said that Sunday 6 days ago. He mentioned it in another interview we did, but it's cut off at the end. It's not part of the recording. That's what they said in trial that just happened. So I think that's a lie. Like, I don't think that happened. But they need to explain how if the max window is 3 days, how it somehow could still be there after 6. So they have this witness say that if it was moved from the vagina to the anus, the clock would restart.
Yeah, but it's still more than 5 days. And it was not semen, or at least they didn't test it. Just as the vagine sample, but that was a presumptive test, not a confirmatory test, because at the moment there are no confirmatory tests. So how does that get in? How does that come into evidence?
Yeah,
when it's not confirmed.
Yeah.
And that BS? Chocolate brown staining on this glass.
With like 4 total cells. The threshold's 10%, and then there's like 4 visible cells. Like, what kind of sample size is that if you need to say something has 10% to meet your threshold?
Yeah. Chocolate brown staining, and it was now there's a range, and the other sample they showed, there's a range between pea yellow to licorice black. Okay, which one of these are the chocolate brown staining you're talking about? It was it was so stupid. And in the middle of everything, true allele, which can't be challenged because it's proprietary. It's a trade secret. You can't change. You can challenge the techniques involved because it's a trade secret. How the fuck was that allowed in?
Well, and also in
should be,
closing,
just objectively.
in closing, Kalki Yamoncelli got into something that wasn't even discussed. I don't think a witness could discuss it, but since they were willing to opine on reset, I feel like if they were asked, they might have gone down this route. But in closing, Yamoncelli tried to argue that the smaller likelihood ratio is magnitude smaller of Melton's DNA being present on the anal swab was indicative that it was transferred there and that it hadn't been there for so long. But we had no opining on that. We had no opining on how transfer would equate to a different likelihood ratio showing through true allele. In fact, the witness said, I didn't do anything with the true allele. I just put it in the software and then got the outputs. And she didn't discuss any of that. And what's even worse is if the jury listened to that argument and they're looking through the DNA report, the second mislabeled oral swab that might be vaginal, that was in dispute, Faust DNA is magnitudes lower on the likelihood ratio. So the same logic that Yamoncelli argued in closing arguments should also apply to Faust presence on the supposed vaginal swab.
Yeah. But here's the sad truth here. I don't think the jury cared about that because they have his DNA and he said he didn't know her.
Oh, Terry just found out about the verdict.
No. Oh, I'm so sorry, Terry. Yeah. Yesterday, they watched Faust interview. They asked for evidence number 167, which was the true allele result, I think, if I remember correctly. And then they went to have lunch, and then they came back with a verdict.
They wanted their dang lunch before they took someone's freedom.
Yeah. And it tells me DNA, in their opinion, it was not supposed to be there because according to Georgia rape shield law, the defense were not allowed to, according to this judge interpretation of the Georgia shield law, were not allowed to even breathe the possibility of a voluntary encounter between Faust and Tara Baker. And then he said, I don't remember her. I don't know her. I don't. And again, it doesn't matter. I don't think it mattered to the jury that he was never shown a photo of her. Because he said, I don't know her. And then when confronted with the DNA, we have your DNA. You have my DNA. Take me to jail. Again, wordings are really important. Don't say, take me to jail. Say, I want a lawyer, because you can't play that recording.
Yeah.
Wording is important, and shut the fuck up. You were read your rights. Now, it was in the beginning of the interview. Yeah, just as standard, we are going to read you your rights. And then later on, but it's a re-technique again. Lie, to get things that you can confront people with.
Well, and it's got to be weird because if you didn't do something, like you might not remember meeting somebody, but you would dang sure remember if you killed somebody and set a house on fire, right? So if you don't remember that and they're saying that you did this fire thing with the girl that was murdered, you set a fire, and they're like, we have your DNA, and you remember that 2 days ago they pulled you over for tint on your windows and then you're doing a breathalyzer test, you might be like, dang, they just got my DNA 2 days ago and they're saying I did something 25 years ago. I'd be like, we're done. I might not word it in the most artful way, even though I know better.
Now, let's talk I don't know what you're talking about, an unrelated on your later stream.
Yeah, I'm
I
calling
guess.
it an a palate cleanser. Like it's going to be an appeals round robin. We're just going to watch some oral arguments. The nice thing about appeals is you're not really supposed to dispute the facts, so it stays away from all the emotional, heart-jerking pieces of evidence from trial. I think it'd be a nice palate cleanser.
Yeah. Now, when it comes to appeals in this case, I'm leaning towards Bob Marda's ineffectiveness of counsel not filing a 412.
Yeah.
That's a given. Then try to challenge the Grape Shield statute, because this case law does not apply to this case. I don't know if this appeal is where you can argue that in Georgia.
Yeah, I think motion for new trial comes first, and that'll be pretty quick. Although it can get pushed out quite a bit, but it should be relatively quick. I'm sure it'll be 412. I'm sure they'll raise pretty much everything. Usually you raise a ton of errors in your motion for new trial just to preserve them. So I'm sure they'll raise all that stuff. Pretty much everything that was preserved, I assume they'll raise. But yeah, I think the 412, ineffective assistance, kind of two sides of the same coin, but I assume those will be raised. That's why Andrew Fleischman, who I think is the best appellate attorney in Georgia right now, he's erred on the 412 issue as well. He would be my choice for defense lawyer on this case.
I think that could go to SCOTUS. That particular issue, I think that could go to SCOTUS.
Yeah, like I said earlier, you can argue it from both sides. If you didn't file it, then it's ineffective assistance. If you did file it, then it's judicial error. So it's kind of a win-win.
Then let's see. Where did I? Oh no, done. Why do I keep clicking away the wrong tabs? We are all professionals. No, was it with Defense Diaries? I argued
I think
the different.
Number 101 in chat says, wasn't his DNA already in CODIS from his previous charges? They sent stuff in for retesting for the cold case in February of 2024, which I have concerns about because Georgia had a contract with Kiogen, and Kiogen was having issues with the reliability of their testing kits then. So wonder if that might overlap that same time period. On April 30th, they returned a possible hit for Faust, and they shouldn't have been relying on that. Liz made representations to the court that she shouldn't have made because it was a partial profile.
Yeah.
Not a, it was a partial match, not a partial profile. So, like, I don't really understand. That means it would have come from genealogy.
Yeah.
And then they speak to Melton on May 5th. Then they get warrants to track all the CSLI information for Faust. They follow him around. They pull him over for tinted windows, get him to blow into a breathalyzer after saying we smell alcohol. He's like, I'm not drinking. I'll do a breathalyzer, not knowing that the whole purpose of it is to get his saliva.
Yeah.
And then they use that. They retest it. And the next day, Liz obtains the arrest warrants that are then why she's questioning him with Jeremy the next day.
Yeah.
So
now, the traffic stop, since it was clearly the traffic stop is bogus,
and that would be an issue of judicial error by denying that suppression.
Yeah.
But they're going to say they got to it another way. But
yeah, we will. I mean, and here's the thing: I've been seeing seeing and reading. And appeals court will use that it was unavoidable. They would have gotten it anyway.
But they clearly needed it, or they would have done the arrest without having to do that between April 30th and May 8th. You get them? I feel like they told on themselves by needing to do that traffic stop because the April 30th hit wasn't enough.
And it was so stupid because where does he live? Go through the trash. They just took a shortcut because they know shortcuts.
Don't get checked.
Even if it should be, it won't. We've seen enough appeal court decisions regarding unavoidability, especially when what's his name, the obvious guilty one, in Massachusetts. What's his name?
Wait, from like Karen Reed or
no, not Karen Reed, but the same investigators. What's his name?
Proctor, Lang.
No, the guy who killed his wife and made her disappear.
Walsh.
Well, yeah, Brian Walsh. Because how they got his search results through it was on in clear sight. Yeah, but still, they had to search through his devices for hours. And they only had this limited scope from his attorney, which was insanely stupid to approve from his then attorney. Yeah, you can search his things. But they got through the in clear sight because, they found it. So it was in clear sight. No, but they spent hours going through tens of thousands of false hits before they found those Google searches. That's like saying, I found this needle in this haystack after I searched for it for hours. And then claimed in clear sight. So appeals court will do appeal court stuff sometimes. And here with the partial match, they would argue we would have found it anyways if we couldn't stop him, we would have searched his trash. We would have found a coffee mug somewhere. Yeah, but you didn't. That's the problem. You didn't.
Yeah.
You put up a sting operation, an entrapment operation to get his DNA.
Yeah. I will say I really like the Georgia Court of Appeals and Georgia Supreme Court. So, well, I guess we won't have the Court of Appeals in this case, but the Georgia Supreme Court.
Yeah, since it's a murder case, it will go directly to the Georgia Supreme Court.
Yep.
And yes, I've been looking on a couple of occasions when it crosses my feed, so to speak. Oh, they have they are talking about the case. Let's listen.
Yeah.
And then I did a mistake one time. Hey, I bet more people want to see this, and then I restreamed it, and I like 12 people, and me going, yay!
Oh, I love it. I don't even care if no one wants to watch with me. You know what? There's really something I love about like the auditory environment of the nicer courtrooms, because the state Supreme Courts, you usually get nicer acoustics, and I just like it. I just like that. In addition to the arguments.
If we're going to the composition of the jury. At the end, there were 12 jurors, only one black person. Jury of his peers, anyone? And they chose the black person as a foreperson.
I think that says a lot about the other 11.
Yeah, none of us want to be the one standing up and reading this. You do it.
Because you'll make us look reasonable. You'll make us look like we're the peers.
Yeah, but here's the thing. Jury of your peers is who lives in that community. And
similar life experiences and,
And the jury wasn't racist. I can't tell. I make a bunch of references, but that's not towards the jury, it's towards the process against Mr. Faust. He had a record. He was convenient. And despite objectively, every piece of evidence tells us that Chris Melton was the more obvious suspect. And they still chose the black guy.
And I don't think it needs to come down to the jury being racist, but it's the fact that race permeated the initial stages of this case by being the lens through which this was approached. And then in 2024, when the cold case unit comes along, we have Liz only refreshing the recollection of Melton and trying to separate from the bad guy, who is Faust, with no real reason except to hold on to the claim that the alibi was verified when it was not.
Yeah.
What's the other differentiating factor then?
Yeah.
You have Chris Melton and you have Faust. And so by the time we get to the jury, it's already passed through that lens of a determination that seems to be based in some sort of prejudice.
Yeah.
And that prejudice might be prior status. It might not be directly the skin color of Faust, if you really want to get specific about it. I'd say that both are possibilities. But Liz certainly, Jeremy said there's nothing wrong with us. We refreshed the recollection of all the people we speak to, but they didn't do it for Faust. So do they see him as everybody? Clearly not. Clearly not.
Yeah,
So.
and how, and the one remark that wanted, again, I have 4 sisters. They share everything, good and bad stuff. And when Liz said he was her boyfriend, his DNA was supposed to be there. And this is a law enforcement person who I bet have worked grape cases.
Yep.
It's almost as she conveniently forgot that the most common person who grapes is a partner.
Yeah.
And
It's not.
a lot
It's
of the time
not
kills.
even close. It's not even close. The most common person who grapes and murders in combination, partner. But here's what throws me off is the arson. Arson is very, very specific. And statistically, when it comes to arsonists, except some known cases and a handful of others, it's basically a white-only crime. At least in the entirety of Europe. USA might have differences, but it is more or less a white-only crime, arson. But you can't throw, statistic is not evidence in trial. Yeah, it's interesting. Statistics is not allowed as evidence in trial because it doesn't pass the hurdle of beyond reasonable doubt because it's statistics. It's a model. At the same time, true allele was entered into evidence here. So, yeah. Which brings us to, at what point, why don't they have to disclose the original size of the sample that they then grew through chemical proceedings? How
And remember,
many cells was involved?
they initially said the woman who worked with the evidence in 2001 said there were things that they just didn't do further testing on because they didn't have enough material. They didn't want to degrade the little bit that they collected. Which again would make you wonder, well, maybe that's why they would have collected 2 oral swabs.
Yeah, just to be safe, collect 2 oral swabs.
So.
Because we know it's going to degrade over time. And the question earlier, there was on one of the swabs they found Faust DNA, but not Tara's. How do you explain that? And I have no I have a theory, but it's not an explanation. And sometimes it was so far gone, it was simply not detectable. That's the, but it's still weird because it was a swab from her.
Well, then there's unidentified profiles in the oral swab too. There's at least 2. And remember, Kyojin was having issues with underreporting, like it couldn't detect all the available profiles, so they could be missing. And for what it's worth, they could be missing a profile on the anal swab that would help Chris Melton. You know, Chris Melton, if he was on trial, could be poking holes at the integrity of the equipment used for this testing and analysis. So,
yeah. And as a, I know you guys are. When did you postpone your? You're only okay. Yeah, but
I'll start in a second.
Here's one question, because I want to throw it in the face of all the haters out there. Katt, if Chris Melton had been on trial, would you have argued Faust DNA as a reason for reasonable doubt?
Of course.
Yeah. Jim?
Yeah, for sure.
Yeah. This is the difference between, how do I say this? Us, as we do our videos, we do our commentary and everything.
Jim is amplified more than the DNA in this case right now.
What am I? What?
Your
what
microphone is all the way up.
Now, here's the difference between us.
It wasn't like that. I don't know what you did. How did you
Yes.
do it like that?
Yes, free everybody.
Free, yeah. But the difference here is we don't really care who's on trial. For us, it is the evidence. What does it actually show, and does it reach beyond a reasonable doubt? We have other content creators who do not give a shit. If that person is on trial, they are guilty.
And even on gut, I feel like there's just more inclination, and I would need more at a trial to be willing to convict anybody. But I think just pontificating, I think visually, I can imagine a scenario where Tara's out one night, Chris is showing up at the house, the car's not there, she comes home from being out, and he's pissed because he already feels like the relationship's on the way out.
Yeah.
And it's her birthday week, and she didn't involve him in her plans to start going out. It's Thursday in a college town. And then he snapped. I can picture snapping making more sense than a break-in where only a laptop was taken.
Yeah. And 5 calls the night before, which was outside of the usual. And my theory is he called her and she told him to F off. And eventually she might have said him, Chris, you're gone. I already have been with other people. Theoretically. And he snapped. And he told us on the stand that he bottles up until he explodes. Yeah.
There's one thing to add to the, which way would I argue? Or would I argue the other way if I was defending Chris Melton? I think it's tricky in these cases. You really need to hammer home that you run the risk. You run the risk with the jury of making them pick one or the other.
Yeah.
And I think that could have been, I don't know if that happened in this case, but you don't want to make them decide which one they think is guilty. You need to hammer, we don't know which one of the two it is, as opposed to you need to pick one or the other.
Yeah.
And that's the thing. I think like the DNA, just because DNA is there doesn't mean that either of them killed her. I mean, she was beaten in the face, but it seems like there wasn't like tearing or anything in the genital area, the groin area. It just looked like some bruising. And from the description, I didn't get the impression that it seemed like the medical examiner was a bit unsure, but noted that there was some bruising. And I don't know if I think that necessarily means, and again, that might not have been the issue Cruz wanted to get into, because he was going to argue that out of anger, the third-party culprit did brutalize her in a sexual manner.
Yeah.
So, I mean, he wasn't going to dispute that. But I think on Chris Melton, maybe there's the option of arguing, like, maybe there was some bruising, but the medical examiner wasn't even sure of it in that area. And this could have been someone that murdered and tried to do a robbery gone wrong, but it wasn't even actually an R and a sodomy.
Yeah, I mean, and if I have to say one more thing when it comes to this trial, now when I go through it, because it is, it's like if we compare with the Karen Reed trial, the first trial, third-party culprit really hammer no, it wasn't Karen, it was them, and it became a mistrial. But the retrial, they all hammered into oblivion reasonable doubt from day one from opening to closing. And that also might have been something lacking in this trial. How good he did the job, how good we believe that he pushed it over to Chris Melton's side. He didn't really hammer the reasonable doubt, even though he had good examples. One thing that I've seen exceptional lawyers do, the art of repeating. Boom, boom, boom. Boom, boom, boom. So, reasonable doubt, reasonable doubt, reasonable doubt. Because people pay attention more if you repeat something.
No
And
house,
the
no Faust.
No house, no Faust. I don't think that worked, if I have to be honest. It might have reminded people of the OJ, and for many people, that's not a positive thing. If the glove doesn't
I
fit,
like
you must
that all
acquit.
you need is one. When you're talking about reasonable
Yeah.
doubt, you're like, I'm going to give you a bunch of questions to ask yourself, and if you could come up with any answer that might not lead to all you need is one, and you're done.
Yeah, the rule out
way to
method.
get
That's really reflected in the statute as well. Georgia has specific reasonable doubt statute when cases are circumstantial. You have to rule out every other alternative, not conclusively, but
that's why I made
every
the
other
rule
reason.
it out song for
The rule out method
Wolfenbarger.
there's a book, rule out method. Yeah, that would have been, are you sure? You have to be absolutely certain it wasn't Chris. Not absolutely certain. You need to be certain that it wasn't Chris.
Yeah. If only 1%, can you rule out beyond a reasonable doubt?
And put it in layman's terms. If you find yourself back there and you say to yourself, well, I think it's more likely that Faust did it and less likely that Melton did it, and I think it's more likely that Melton and her were still talking to each other, that's not reasonable doubt. More likely than is not reasonable doubt. So if that's still weighing, you need to acquit.
Yeah.
Because I think people think everyday language terms of more likely than not, rather than reasonable doubt.
Oh no! Hold on.
Oh God, what happened? Are you following that 2001 Twitter account where they just tweet as if it were 2001? Because there's about to be disaster. So there's a Twitter account called 2001 like live events or something, and they're just tweeting as if it were 2001, and Dale Earnhardt's about to die, and it's been getting a lot of hits today. It's the Daytona 500 today.
Dang,
and Nick just said, oh no, and I thought maybe he found out the bad news 25
Folks, I said we were winding. No. Doug!
Oh, Doug!
Hey,
hi, Doug.
Hey guys, I'm not gonna look at you because I'm driving.
Yeah.
Safe.
Hi.
It's relatively safe. How's that? Yeah. I got to go to beautiful Tifton, Georgia this evening. So.
Good to have you here. Good to see you again, by the way. Good to see you again.
So y'all have been talking about the Faust case, I assume.
Yeah. We are having a why stream, as in how and why could they go beyond reasonable doubt. And we more or less concluded, I think, that his DNA was where it wasn't supposed to be, and he said he didn't know her.
Yeah.
And sadly, for a lot of people, that's enough.
That's the problem. If the jury decides you're lying, period, they convict you.
Yeah.
I mean, that's the sad reality. I mean, don't you guys agree? I guess you do. That's why you got there.
Yeah, and by that, they also went, well, he must have done this inside the house, which means he had to have broken in without reflecting that those doors were locked from the outside. How did they get the key? And the key was still with Tara. So they ignored a lot of evidence. So yeah, they came to the conclusion here, and because we came to the conclusion over here, he must have done all the other things as well. And
I think it's more simple than that. I think it is the jury decided he was lying, and so they just convicted him of everything. Although they did spend quite a bit of time, so that would make you think they at least stepped through the elements in the judge's instructions. Did this judge send the jury instructions back with the jury?
I think so. I think they all got copies.
Okay, because in Georgia it's not consistent, right? Sometimes they do.
I think they printed 12 copies. I remember them saying something like that.
Yeah.
Yeah. So, but I still think the jury decided he was lying, and therefore they just convicted him of everything.
Now, you as licensed and practicing, we have been talking about the Georgia grape shield law, and how there is by statute no opening the door from the state.
That's kind of correct. I mean, the way I read the Georgia rape shield law in conjunction with the rest of our laws is that absurdly, you cannot get into the essentially sexual history of the victim, but if you want to go there on the defendant, pretty much have at it.
Yeah. So it's a burden shifting, and
shifting. I just don't think it's a very just situation that you have all kinds of ways to introduce into evidence the defendant's prior issues that's essentially propensity evidence. Yet you cannot bring in anything close to that with respect to the victim.
And then the jury wants to hear from the defendant, but that puts the defendant in the bind to take the stand because they're going to get confronted about something that the complaining witness couldn't be confronted on.
And reading the case law, I skimmed through it. Those are just one-on-one encounters. Both people are still alive, and this is not that case. If this goes up to a higher court, well, you never know what a higher court would declare. But for me, the more I read into it, the more I see it doesn't apply to this case. Yes, you have the grape element, but you also have the murder element, which is not addressed at all in the statutes, in the case law.
No, but because there's a rape count there,
then
the rape shield law kicks into effect.
Did
Cruz? I'm trying to remember because I think I was actually maybe still in trial when this case started. Did he attempt to bring in some issues and file the appropriate notices before trial to get around aspects of the rape shield law?
According to Judge Lott, he did not file a 412. An exception from
there's a potential issue for appeal then.
She did explicitly find that there was no motion filed. I think that's in dispute, but there was a finding by Lott that there was not one filed, and I think that bodes in his favor for a motion for new trial. The judge did explicitly find that none was filed and that he was trying to proceed as if one had been filed, which seems to me to militate in favor of finding ineffective assistance, because it's just failure to execute your strategy at that point.
But then the defense tried to argue around it by saying, we just want to have into evidence this witness who said she might have seen Tara at a bar the evening before, and use that against the investigation, because they never went to that bar and asked for, do you have any video? Did anybody else? Hey, you bartender, did you see this woman? Nothing of that. But according to Judge Lott, now you just want to circumvent, and I'm not going to allow it.
Yeah.
And for me, it's like, but don't you have to and do a full analysis of that exception and then weigh it against?
Of course you do.
Yeah, but she didn't.
But as
She
I said on the X machine, because of some situations I'm in, I'm not going to criticize this particular judge on this trial.
I saw,
Potentially
yeah.
clients of mine. The main thing I took away from this guilty verdict, I know people were really, at least on X, which I don't know if that's the best sample size, but sample, but viewed this as a lynching, and they can't believe the jury came back this way. Again, I mean, there's two main lessons from this, I think. One, if the jury believes the defendant is lying, and I had a conversation with Bruce Harvey about this, not about this case, but just in general. If they think your defendant's lying, they're going to convict you. I mean, just period. They're going to convict you. Forget the elements. And then the other thing is just, I hope people appreciate more why folks will take a plea when the public may criticize them for taking these pleas. You never know what a jury is going to do. You don't. You just don't.
We saw that in the YSL trial, people making criticism. And in retrospect, nobody should have pleaded out. But you don't know.
In retrospect. But you don't know that at the time. And you don't know, before you selected a jury, you don't know. And once you've selected a jury, the plea offer is usually not on the table anymore. So these are gambles that defendants are taking with their lives, and they have to decide their tolerance for risk. And another example, you mentioned YSL, and I guess you're referring to that Jeffrey shouldn't have taken a plea, or people saying Jeffrey shouldn't have taken a plea in hindsight. But I'll tell you, in YSL, I was terrified, even in closing argument, that Diamante was going to be convicted on RICO.
The watch
question.
question.
The state's RICO case was so strong, and the jury, when I talked to the jury afterwards, they're like, "Yeah, we knew there was no RICO. We just dismissed that one right away." I'm like, that's all I have fixated on forever is RICO. And so I don't, even after watching this jury and being in a room with them for over a year, I didn't know what a jury's going to do.
I remember Kokomo did an interview, I think the day of the verdict, and he was saying, I couldn't read them. They had stone cold poker faces. And then once you hear them speak, it's clear, what they were thinking. But Kokomo said he was staring at them for a year and he had absolutely no idea what any of them were thinking.
So I don't
if you were
know
sitting that close to the state's table, you keep a stone face too.
They weren't. I don't totally agree with Kokomo that they were completely stone-faced. There was one juror that was an alternate that I felt had a bit of a crush on Adrian Love and wanted to
I think I know who you're talking about.
Play bunco and drink wine with her. But and there were others that I think liked us. But back to this case, I don't know that. I think the criticisms of this jury that they're racists and this lynching, I think that is extreme. I think it's really as simple as they thought he was lying, so they convicted him.
We talked about this earlier, and we are in agreement here. This is not on the jury. The jury only heard the evidence as it was presented. They didn't hear when things that happened when they were out of the room. They heard the case as it was presented. Now, everything leading up to it, how the lead detective gave the Chris Melton his alibi. You have to get us closer in time. Now then you can make the inferences. Why does she so adamantly want to pin it on this guy? And when you boil everything down, you come down to prejudice. It's his boyfriend, as you said on the stand. It's her boyfriend. His DNA is supposed to be there. And if you have
And so-
spent a week in a courtroom, you know that's not true. Boyfriend's DNA aren't always supposed to be in that location. The most common person who rapes somebody is a person near. The most common person who murders is someone near. I mean, I think you're muted, Doug.
Oh, now I hear Doug. I hear you,
Do you
Doug.
hear me again? I'm sorry, I had a phone
Yeah,
call coming in. I didn't
No
put
worries.
it on Do Not Disturb. My apologies.
No.
The other thing, and I think I've heard Katt say this, and I'm sure you have both said it. People that watch the trials, I think, need to appreciate a little more what you're saying, Dick, which is the jury is not privy to all that we see on the streams.
Yeah.
They're only seeing the evidence that's allowed by the judge to be admitted, and so
Yeah.
their universe is a smaller universe of things to look at.
Yeah, and I think this is something with that we, as streamers, might go into more when we see this happening, even on X and in our chats, and even on the Law and Crime chat. No, out of everybody in a courtroom that is not to be blamed over a verdict, even though we adamantly disagree, we have so much more information. We can rewatch things. We can discuss the things. We give out our opinions, which might affect people. And we have to be clear with that.
Yeah.
Very, very rarely.
Yeah.
It's the
And the jury,
juries.
as you hear the judge admonish the juries or remind the jury jurors, they're not even allowed to begin discussing the case until they're in that jury room. They have a copy of the indictment. They have the exhibits. Then they can begin to discuss.
Unless you're in Indiana, where Mo in the Deep End was in a jury, and the judge allowed them to discuss the case on breaks.
Yeah, well, I only know Georgia. I have a very limited field of view.
Yeah, and I was like, "Are you sure?" No.
Yeah.
So, but also, for me looking in, first of all, learning the generality of the U.S. system has been. I mean, I've been doing this for over 3 years, and I'm learning something new every day, every damn day. And for instance, yesterday when I learned about the exception or the non-exception in the Georgia rape shield law. No, the state literally, according to statute, can't open the door. And I'm like, what?
Yeah. And I don't know. And Jim, were you the one that posted that insane case out of the Georgia Supreme Court, where the guy was waiting, 13 years, 17 years for his motion for new trial even to be heard?
Yeah. There's a longer one apparently this week. McBurney ruled on one from like 2002 or 2003. So I think that's going to be coming up soon. But yeah, I did post that.
Yeah. And we've been haunting Fani Willis and Chief Judge Glanville for not doing cases that are a year old. I mean, and then you have people who... Jim, didn't you know a case about a person who has been in jail for over 5 years without a charge? Or up to 10 years? No,
Probably.
who was that?
Oh, yeah. Sometimes I go through so there's an interesting thing in Fulton County, the jail. They actually have pretty good data on when people come and go from the jail. So you can just go into their data set and pull out current inmates in Rice Street and see, well, it's not just Rice Street, it's all Fulton County, but it's mostly Rice Street, and see who's been there the longest. And you kind of have to go, the longest ones are usually, this is a separate problem, also a problem. The longest ones are usually people not fit for trial. So you have to go through the case numbers. But usually, I think the longest is about 6 or 7 years at this point. It was a co-defendant in a murder case. It's a pretty troubling case, which is why I can understand why they'd be hesitant to let the person go, but it has been 6 or 7 years at this point, certainly.
Well, the
Yeah,
case
you just
Bruce Harvey
reminded
and
me.
I'm sorry, go ahead, Katt.
Oh no, go ahead, Doug, because I'm gonna switch. It's a little bit of a different topic, so you first.
Real quick, just the case Bruce Harvey and I just tried in Clayton County. Our client has been in Clayton County since, I want to say, May of 2018, and we just went to trial. But that is because of the double witching, I guess, of COVID coupled with the YSL trial. And then the backups from that. But he'd been waiting 8 years to go to trial.
Yeah.
So it can happen. I'm sorry, Katt, for throwing
Oh
that in.
no, I was just gonna say Jim got me thinking something I had as a bonus that he doesn't know about for our
I know
appeal round robin. It's actually an insufficiency of the evidence argument that won on appeal that relates to kind of the bookkeeping at the correctional facility comes into play in the decision. So
Interesting.
pretty excited for that.
Yeah,
Won't go further into it because that'll be a spoiler.
And speaking of that, gets us back to cold case evidence having a lower standard of evidence, as the judge implied in this case. That was appalling to hear. This is a cold case. It was regarding when
Phone
they
records is one
unpacked
example,
the
too.
slides with the hairs and the samples and everything. A bunch of them were cracked, and she said, "Well, it's a cold case. Things happen." And I'm like, "No, these are supposed to be secure in a box in a locked area. How did they break?" And they lost the entire window screen from evidence locker.
Lots of evidence can go missing. Like,
Yeah.
if you recall in the YSL case, there
Let me check the time.
it got lost in the hack, the great fault in the hack that caused everything to be destroyed.
Yeah.
Things disappear in evidence.
Actually, this was a cold case too. This was a Fulton County cold case from 2012 about a 2002 murder. And the case had actually been cleared. The two suspected killers had been killed in retribution the same day. And then a jailhouse snitch came around and said, no, these other people also did it. And there was a gun that supposedly tied these three defendants to the killing. But then the gun was destroyed before trial. So the prosecution got the GBI report saying that this gun tied these three defendants to the killing, but the gun was
No
nowhere
equal
to be found
opportunity to test on
because
your
it had
own.
been switched from evidence to property and then destroyed. And those three guys are still in prison. I'd name the prosecutor, but
I think
don't
one
think
of
I
the
need to.
detectives is down bad.
Oh, is it a Miss Love case?
I didn't say that.
So this case hasn't been
It
tried
was.
yet?
No, they've been
Did
in
it go to
prison
Georgia
since-
Supreme Court?
Yes. So this is the other thing. That gun was not the murder weapon, but
The
the
smoking
prosecutor
gun.
called it the literal smoking gun in opening statements.
Like,
It was the wrong
like
caliber.
the word literal.
Unambiguously not the murder weapon, and it had been destroyed. But yeah, they've been in prison since 2013, I think. And in Supreme Court appellate briefing, the state continued to double down and say it was the murder weapon, even though A, it had been destroyed, and B, it was the wrong caliber.
Fulton County's appellate lawyers are honestly usually better than that. Usually, not always.
Yeah,
Well, and sometimes they're in the unfortunate position of they're there to argue for the state on what they have no good argument. So
But you know,
they got to do their job.
I wish I could remember the case. I just read a Georgia Supreme Court case. I want to say from January, where the
Maria,
the appellate
second
lawyers
retrial?
it's where the appellate lawyers basically admitted that the state had made an error. I mean, they acknowledged it, which is the wise thing to do. If you want to try to win the appeal, they didn't double down. Usually the Supreme Court will sniff through doubling down on a bad position. The best thing to do is to own the bad position and then explain why it doesn't matter, or explain some way around it. That was not a Fulton County case, by the way.
Or hope they only opine on that issue and not any of the other enumerations of error.
Yeah, I think the state AG's office, I think their appellate team's pretty good.
Oh, yeah. The state AG's office in general is pretty good if you ignore their tremendous Cop City screw up.
Yeah.
That just got I don't know if you saw their what's it called? Petition discretionary appeal or discretionary. I can't think of the word. I'm blanking. It just
From Judge Farmer's decision on the Cop City case.
Yeah, I was just granted this last week, I think.
Yeah, Judge Farmer's right on that, by the way. He's 100% right.
I love that ruling. It's just the
Aquarius Rising. So are we assuming he's going to appeal? Well, yeah, he will. Who pays for his legal representatives for the appeal? Probably the state. He will be assigned an appellate attorney from the public defender's office.
I thought I just saw on X someone volunteering their services for that.
Oh.
Yeah, it was Colin something, I think.
Yeah, something like that. Yeah, I saw that. Yeah.
Yeah, I'm not sure if that will be full on appeal or like working to do some research, like as a consultant to the team, rather than actually being the one to like would litigate be the term.
I assume it would be the motion for new trial first, but then an appeal after that.
Yeah.
No, they have. There are some steps. I mean, motion towards this judge. Yeah, we need a new trial, which probably won't happen. Then you have a motion if they want to add stuff to the record or complete the record. You have lots of stuff that goes on before the first appeal goes on.
Yeah, I dropped his. Oh, actually, didn't let me post
well,
it. So his name is Colin Miller on X.
A self-drive safe doing this. I'm about to go through
a bad service area.
Yeah. Okay.
Yeah, I just looked up Tipton. Yeah. It's way down there.
Yeah, and Doug is breaking up. And... Yeah.
Oh, am I? Oh my gosh. See?
No worries.
I can hear you okay.
Because they have to speak for justice.
Maybe it's just me. And he's gone.
Ah.
Yeah, laws of service. Thanks, Doug. Thanks, Doug, for sticking around for a bit.
Georgia has some funny
Everybody who
names.
said no, said, "Oh, sorry, I don't have the time." Ta-da! You came here. I'm so happy to have you here to try to.
Who doesn't love Doug? Oh, so I just want to double down on the taking plea agreement thing. Like, you got to take so often you have to take the plea. I mean, it's just like if you're strictly a rational person, even if you're innocent, that's what really bothers me. Like, there are so many situations where, like, even if you're innocent, it's rational to plead guilty. Like, I have clients that they would be free now if they had just taken the plea. Yeah, I didn't do the trial, so I didn't lose, to be clear. But on habeas, they would have been freed years ago. But now we have to do this stuff.
Yeah, that is something that has to be taken into account. No, we don't have that system over here with plea deals. It's you go on trial.
Yeah.
Now, in lesser things, there is a way for you we have, for instance, over here, defamation is a criminal offense. Yeah. That you can make a plea of guilty. And then you get fined, and then off you fuck.
Yeah, I said that shit, and I meant it.
More or less. And but yeah, those are to get rid of the petty crimes. You get the option of they present the evidence to you, your attorney.
Yep.
And then it still has to be signed by a judge. So, but it's like anything that is not prison in the scale. Those can be maybe a version of pleading out, but everything else, no. You're going to have your trial, and you will face a judge and 4 layman judges or professional jurors, depends on how you see it. We appoint our jurors, and then our jurors take a course in how to be a juror.
Yeah, I think people have this perception about like pleading out where it's like, oh, you're charged. Judge doesn't have murder 1, murder 2, but like, oh, you're charged with murder in the 1st degree. We'll plead you out to murder in the 2nd degree. Where sometimes it's like
Yeah.
murder to like aggravated assault. And
Not to reference
not
any
just an
familiar
example that came to
trials.
mind, but you can get some that or battery or something like that.
Yeah.
Where it's
And
Without consulting the victims' families first or anything,
And I mean, I've been watching a lot of George Simpson and the first stages of everything, and there are so many DUI cases, and they plead out to a lesser, and off they go. It's not until like DUI number 5, 6, 7, we might not accept. We might not give you a plea deal this time because you have 6 of these in 5 years. But other than that, off you fuck. Because there's simply no time. I mean, the U.S. justice system would break if people stop pleading out.
Yeah. In like a day, too. It's not even like it would break down eventually. It would fall apart tomorrow.
Hint. First of all, Bruce Harvey's business card on the front.
Shut up.
The Bruce Harvey attorney, in quote, shut up. Then you turn it around. Seriously, shut the fuck up. And which brings us back to this case. For the love of fuck, Mr. Faust, the moment you stepped into that room for an interview, you've been there before. Shut the fuck up. Lawyer up.
Yeah.
Because the most incriminating thing is, as I've seen many say, and I agree, his DNA was not supposed to be there, and he said he didn't know her.
Yeah. And
if he had lawyered up while he sat down, there would have been no statement to play.
Yeah, that gets to Doug's point about if they think you're lying.
Yeah.
Yeah.
If a cop thinks you're lying, they're going to ask questions and keep asking questions until you are incriminated, and then they're going to drop the bombshell on you.
Yeah.
Well, I think it adds that extra expectation that why not just take the stand, right? There might already be a baseline expectation that if you're innocent, why wouldn't you take the stand?
Yeah.
Or a jury might not think about that and all the considerations the way we might as watching trials. But then if you say something in an interrogation video that's so damning, why wouldn't you just get up and tell us why that's not what you meant?
Yeah.
So like it just heightens the expectation to take the stand.
Yeah. Yeah. Oh, we are almost 2 hours in. Katt,
yeah, I'm gonna yoink myself off because that sounds bad phrasing. But I'm gonna get the StreamYard ready. And Nick, I sent it.
Are we done? I wouldn't have noticed it when you said that.
Gotta own it. See, this is why you don't talk. This is why you just shut up.
Yeah.
But Nick, I sent a link on X if you want to join over. It's set for right now to start now, but I'm gonna get some ice and a refill.
Wait, did you send me one?
Start in like 5 minutes. Yeah, I should have, right? On X. And guys, we're gonna just be looking at appellate arguments. I think there's a few different cases in the state of Tennessee. One that I definitely want to watch. The others I don't know any background for. We could watch, and then we could read one if you want. The one I mentioned earlier.
Now it's 10 p.m. here, and I have work tomorrow. I might pop in for a bit. Folks, you're going to be redirected over there. And I know the redirect doesn't always work. So I'm going to post link here to the...
Okay, I guess I'm going to bounce off then.
Okay, yeah. Thanks, Katt. Bye. Yeah, so I posted the link in the chat. The links to both Jim and Katt is in the chat. And let's go. Chicken Poo, thank you. Your California $2. No, Canada $2. I'm so effed up about this case. Yeah, we all are. We all are. And thank you to Derek for your super sticker. Oh, that was a while ago.
Yep. All right.
Oh,
I'm going to bounce off, but 2 hours on the dot. I'll see you guys.
See you. Thank you so much.
Thanks for having me on, Nick.
Thank you for being here. And then there was one. There. It's a peach with boxing gloves. Thank you. And Charlie, thank you. Sorry for not bringing it up sooner. Look at the dineros, resources, and time it took to keep Karen Reed out of jail. Yeah. It's a good comparison. This is a what if. What if now Faust had a good defense team. Did they make mistakes? Yes, they did. But better than average defense team. Definitely. His defense attorney he's going places with the experience of this trial. He will become better at the next one, much better. And in the what if Karen Reed was just another person, if she didn't have all the savings she had, the house she had, the parents and the rest of the community handing literal millions into her defense, there's a strong possibility she would be in prison now. But folks, I'm going to send you over now, and thank you so much. For you who don't know, my goal this year is I want to beat Laura Owens. Not physically, Laura. This is not a threat. She made $83,000 from her podcast with her mother, which they split in between, according to her. $41,500. Folks, shouldn't me, who is much more lovable, much more knowledgeable, much more handsome, much more everything, and Mr. Jingles, don't we deserve that too? Don't we? Folks, I'm joking. Here's what I always say. Do not dare give what you don't have. But if you're one of these persons who this is my third Starbucks latte. Hand over one of them. Why don't you support this channel? Yeah, really, a Catman said, Nick, you're sane. Rage bait pays, but it ain't worth it. Yeah, I know. I don't think I'm able to be one that just rage baits for cash. I don't think I'm able to. Do I rage on occasion? Oh, hell yeah. Do I curse like a motherfucker? Seriously. Usually, you hear me cursing around to the extent that my streams are demonetized by YouTube. That's not unusual. But if you're so inclined, but if you don't have the means, like my videos, watch my videos, comment on my videos. It gets me some ad revenue. And do that with Jim and Katt and every of the content creators you watch and love. Okay? But from me and Mr. Jingles, thank you. Without you, this here would not be possible. And remember, folks, hug your family. Unless they're crap, then screw them and give your love to the people who deserve it. And as a waving off, here's a song about shit science.
Step right up to the miracle station. We've got justice in a jar on sale. Wave a lab coat, sprinkle Latin, sign your name, then set that scale. Look, a scratch on a screwdriver. Look, a pattern on a shell. Call it tool mark analysis, baby. That's how they send you to a cell. It's a shit science and you know it, but they sell it with a wink and a grin. Draw a line, call it math. Write a number on a latch, then they swear that the truth's locked in. Shit science. Showbiz in a lab coat, give the jury one more magic trick to quote. They clap, they sigh while a life goes by on a shit science song and dance they buy. Open wide, says the expert smiling. Let me measure every jagged tooth. Bite mark analysis on a bruise in a photo. They announce they've discovered the truth. Here's a cheat, here's a mole, here's a slideshow. Turn the guests into gospel on a screen. They don't mention all the bodies that this carnival left in between. It's a shit science, and you know it, but they built it like 11 o'clock tune. They project, they breathe, they perform on the stand while a family waits for a June. It's a shit science. Glitter on a gravestone. They make certainty from shadows alone. They rhyme might with must, turn maybe to must on a shit science chorus of trust. Here's a hair in a plastic packet, microscopic match. They shout on cue. They compare, they declare from a single little strand, like a crystal ball come true. Then a tape in a humming courtroom. Listen close. Do you hear that line? Voice print and Alice on a swiggle in a graph. They pretend it's a fingerprint sign. And you know it, still they stage it with a spotlight glow. Every chart, every slide, just a confident pride. But the stakes are too high for this show. It's a shit science curtain call 'em bad odds. Time to tear down this cardboard facade. Cause a man can lose his life to